Good morning,
Mr.
Your Honors.
Houghton.
William Hamilton for the appellant, AA Transportation. With me is Richard Jones. This case comes here from a denial by the Appellate Tax Board of AA Transportation's request for abatement of sales taxes that were paid in connection with the purchases of buses used for intra-city transportation. The statute, the relevant statute is Section 6, small double A of Chapter 64H. There's two provisions in the statute for granting the exemption. First of all, the common carrier must be providing intra-city bus services, and second of all, the taxpayer must hold a Section 7 certificate.
I have a question.
Yes.
Did your client have a common carrier license when they were picking up people on these bus routes?
Yes, they had one.
They had a common carrier license at that time?
Well, they had a license that was issued pursuant to Section 11A of Chapter 158A.
Is that a common carrier license?
I'm not sure I know what the distinction is between common carrier.
Common carrier is somebody who picks up on every street corner, like the bus
Yeah, I
company
think the
does.
DTE refers to that as a line license, but I know they did not have one.
Well, then, were they operating illegally by picking up these people on these routes?
When AA Transportation acquired the assets of Weagle Bus Company in 1996, Weagle and then AA Transportation was providing school bus services. They were providing services for the Worcester Regional Transit Authority. They were providing services for the Massachusetts Bay Transit Authority, the MBTA, and they were providing charter services. So it was an umbrella. If you look at Section 11, requirements under Section 11A and Section 7, they're identical. It says, in order to get the license, it's got to be in the best interest of the public. It's for the public convenience and necessity, and you have to be financially fit. Other than that, it's just a piece of paper.
Maybe I'm mistaken, but I was always under the impression that in order to pick up people on a bus route and have them pay $1, as your client was doing, that you had to have a common carrier license.
It's, again, it is under Section 7. However, Brian Christie of the Department of Telecommunications and Energy, the DTE, testified, and he was the department's expert, that at times there's a special provision under Section 11 that allows you to pick up people along the route. And when asked, well, what if someone's operating a common carrier license without a common carrier license, he said, well, it happens. Well, what do you do?
Yeah. Mr. Houghton, has the Attorney General, I mean, I know the Attorney General challenges the assessment of taxes here, but has the Attorney General challenged in this case the right of AA Transportation to operate in this way?
Now, it's interesting because after the hearing, we put this in the brief by way of illustration, AA Transportation decided to operate a different bus route, a common carrier, if you will, bus route, a line route. And in April 29, 2002, they instituted, and that was between Maynard and Acton, regularly scheduled stops. They did not have a Section 7 license for that. They did not have a Section 11 license, 11A license for that. They had no license. They operated. And you cannot operate a bus service within the city of town without the chief of police knowing, and and this came out in testimony, and without the selectmen knowing it. No one's going to go into a town and start picking up little kids and elderly people without gathering attention.
But you got a license for that. You got a Section 7 certificate for just that route.
We did get it later, but we started in April. We applied for the license in June, and it was issued on August 22, 4 months after we started the route. In the meantime, we also applied for an exempt use certificate from the Department of Revenue that we're conducting this exempt activity, and we want to buy our buses tax-free. The Department of Revenue issued us Form MVU 20, exempt use certificate.
Let me ask you this fact question, and there's actually two questions roll into one, and it's for purposes of the definitions under 49 U.S. Code Section 14501. I take it, the way this bus was operating and where it was operating in the city of Worcester, it was A, neither a charter service, and B, it was not on an interstate route.
It was not on an interstate route, that's correct.
And it's not on and it was not operating a charter service as it was picking people up on different corners for $1 a head.
Unfortunately, this is, nothing is so clean cut here. We were operating a route pursuant to a contract with UPS. Our employees, and this came out in testimony, our employees are intercity people from Worcester that don't have access to private transportation. So we would pick up UPS employees, and along the way, at various stops, pick them up. We were following the same route that the Worcester Regional Transit Authority used, Route 5E.
Yeah, but you were picking up members of the general public as well, for $1 a person.
What happened was,
That's not a charter service.
we actually did not brief the federal issue in our appeals.
Has the Attorney General made the claim? I mean, is that issue in this case?
No, I think at this point, it simply comes down to,
The
do we have a
preemption issue?
license? When are we required to get a license? Whatever. Again, remember the facts here. We were doing this for the benefit of our workforce, and we were picking people up along a certain route that was identical to the Worcester Regional Transit Authority route. But the government doesn't provide service 24 hours a day. The government doesn't provide service on weekends. And so, but we do. And so the general public, I guess that poor people have to do their shoppings on weekends, have to visit family members. On holidays, they want to see people. Who do they turn to? They turn to AA Transportation. And at first we resisted, and there was such an outcry, we said, okay, you can come on our buses. We're going to run it like a line service, $1 a piece. Everybody's happy. So we had kind of a mixed operation here. AA Transportation, looking backwards from when they purchased the operations from Weigel, and Weigel was working for the MBTA and Worcester Regional Authority, thought all you need is the Section 11A license. And in 2002, when AA Transportation went to DTE and applied for a Section 7 license, said, you don't need one. You already got 11A. It's the same thing. And so they didn't get it. Our point also in this case is that in 3 letter rulings that we cite to back in 1980 and 82, the Department of Revenue had the same issue. What happens when you have an operator?
But weren't those all cases that involve the MBTA, though?
They were, but
Which isn't covered by, you can't get a Section 7 certificate for?
I don't know that is to be the truth, that you can't get one. I know that you don't need one. But the point is, that if the government's position is that exemption statutes must be strictly construed, then construe them strictly. They did not have a Section 7 license. They should not have been granted an exemption. But in those cases, the commission looked to the purpose of the statute. It was to promote intra-city bus services. And they said, okay, it doesn't fall neatly into the statute, but at the heart of the exemption, they qualify. We're not going to rely upon a technicality. We turned to this case and we said, at the heart of the exemption, we were providing services for people that had no other alternative. And so what is the difference between my taxpayer and the taxpayers in those letter rulings?
Could I ask you a question? I'm sorry.
Okay. The bus purchases here were made from 1999 through 2001,
That's correct.
and were they purchased to run on this route? Is it 5E or whatever?
Yes.
That's what they were purchased for.
Yes, that's my understanding, and the department looked at it, and I think it was agreed to that, and the statute simply says if you hold one certificate, then your bus is, any bus that's using in this particular manner qualifies.
All right, but
So
you concede at the time that you didn't hold a certificate.
we did not hold a Section 7 certificate. That is not in dispute.
Okay. But, go ahead, excuse me. Yes.
Please go for it.
No, go ahead.
Well, do you dispute the general rule that one taxpayer can't rely on a letter ruling for someone else?
It's funny because that is in the regulation issued on public pronouncements by the Department of Revenue. You can't. But then they publish them in something called Mass Tax Guide. If you look at the Mass Tax Guide, I think it's a 5-volume set. All practitioners get a new set every year. And it includes all the regulations, letter rulings, DOR directives, technical information lease, Department of Revenue. And I read it last night. You open up the front cover, the Commissioner of Revenue's letter, dear taxpayers and tax practitioners. This is the official publication of the Mass Department of Revenue, and I'm paraphrasing now, forgive me. It is meant to ensure fair, consistent, and honest tax administration. Here's what the rules are. People like me use that daily. And when we're advising a bus company, we look in the index. On the buses, we look, we see the statute, we see 3 letter rulings, and we advise people consistently. Now, I think this is similar to Middlesex Bay Banks, I believe the case was, where the question was instructions. And this court held, even if the department's 35-year-old policy or interpretation was wrong, it published instructions telling the taxpayers what they can and cannot do. In this case, they publish letter rulings that are issued to third parties. But I think maybe we can't rely upon because the facts are not identical, but you got to look at the intent behind it to advance the public policy of encouraging intra-city public transportation. And at the heart of...
Can I stop you on the intra-city for a moment? Your position, I take it, is that the bus made several stops in Worcester.
Yes.
Therefore, it was providing intra-city transportation.
Yes.
And then it traveled to Shrewsbury?
That's correct.
And did it make several stops in Shrewsbury as well, or was it just Shrewsbury just another end destination point?
The testimony was that it made multiple stops in both cities. There is the Worcester Regional Transit Authority Route 5A is in the appendix, and it's unclear because the testimony was it was the identical route, but we may have made more stops than the Worcester Transit Authority. So yeah, we're saying that it was intra-city bus service, and we think the board failed to draw a distinction between an intra-city route as opposed to providing intra-city services. And the statute says...
So you may have traveled to different cities, but within those cities
Yes.
you provided intra-city service,
And
scheduled intra-city service.
And even though the statute refers to intra-city as defined by the DTE testified, we don't define that term. We don't even use that term. And so, you know, but then when they issued us the Section 7 certificate in 2002, between Maine and Acton, it lists 2 different cities in Appendix
Is that
A.
considered an intra-city route?
Excuse me?
I wanted to ask you, is the Maynard-Acton route considered by the Department of Public Utilities now? Is that considered a intra-city bus route?
Yes, it is. And that's why they issued us the Section 7 certificate, and that's why the Department of Revenue issued us the exempt use certificate from MVU 20, because both agencies acknowledge, even though you have 2 different cities involved, within each city you're providing intra-city service.
The section, I haven't looked at Section 7. Does Section 7 only, are those certificates only for companies that offer intra-city bus routes?
No, I think they're for line routes. But again,
So that isn't necessarily why they issued you the Section 7 certificate?
well, but the Department of Revenue in Section 6 double small a refers to intra-city
No, I know
bus
that.
routes, and they granted the certificate based upon the Section 7 certificate issued by DTE with the Maine and Acton route. So I think all the parties agree that it's intra-city.
So you're saying that it's intercity if there are at least 2 stops within a city?
Yes, that would be intra-city. I don't think there's no requirement that you have 10. I think if you're providing service within the city, that's sufficient. And we do provide multiple stops, regularly scheduled. Excuse me. This is a bus route. It looks like a bus route. It smells like a bus route. It's $1 trip. And it's $1 trip at midnight, on weekends, and on Christmas. And for people that can't, have no access otherwise.
Can you tell me what the city schedule is for its buses?
We do know it doesn't run 24 hours a day, and we know it doesn't run on weekends, especially Sundays, and it doesn't run on holidays.
When does it stop running? Do you know?
I'm afraid I don't have that, but it's in the appendix. So, I think I have 6 seconds, 7 seconds left.
No, you've actually got no seconds left.
So essentially, that's our position, and we're saying, and under Section 6, the exemption statute, it's not pure exemptions. This court has held most of the terms in Section 6 are purely definitional. What is manufacturing? For instance, this court had placed no special burden on companies claiming manufacturing status because the court said it's merely definitional. It's not a pure exemption. So in this case, the issue is definitional. What is intra-city bus routes? And in fact, the board looked to, I think, the American Heritage Dictionary to determine what is intra versus intra versus inter.
Mr. Halcombe, your time is up.
Well, thank you very much.
Thank you.
It's always much shorter than I anticipate. Thank you very
I
much.
wish I could say the same. Ms. Miller?
Good morning, Your Honors.
Good
Jennifer
morning.
Grace Miller from the Attorney General's Office, here today on behalf of the Commissioner of Revenue. Your Honors, AA Transportation is not entitled to the exemption that it seeks here today under Section 6AA because it did not have the Certificate of Public Necessity and Convenience that was required at the time it purchased the vehicles. It purchased the vehicles in 1999, 2000, and 2001.
Is there any reason why that isn't the beginning and end of the case?
I certainly agree, Your Honor, that it's the beginning and the end of the case. Without the certificate in hand at the time they purchased the buses, there is no exemption, Your Honor.
What about fairness? Your brother explains that they're really just providing a service to poor people who need to travel, and you haven't given the exemption to other entities that didn't have a certificate. Why not them?
Well, Your Honor, I think it does go, the fairness issue may very well have been why the legislature passed the exemption to begin with, to encourage intra-city bus transportation where there may have been a need. However, exemptions to the established taxes, such as the sales tax, are always construed narrowly, Your Honor, and that's the rule. And the statute requires that that the common carrier have a certificate in hand at the time it purchases the buses.
It's silent on it. It doesn't say that explicitly. That's how you interpret it.
Well, the plain language of the statute, Your Honor, includes that necessary implication. Because what does it say? You have to purchase these vehicles to perform a specific function by a company which holds a certificate. It doesn't say may have a certificate, may produce a certificate in 6 months.
Let's take Mr. Hampkin's example of the Acton Maynard line.
Certainly.
First of all, do you consider that intracity?
Intercity?
Intra-city?
Intracity? Well, under the board's definition, under
Well,
the...
no, I'm not asking that. I'm asking you what
Well, the certificate was issued under Section 7.
Yes.
And under Section 7, there is no requirement that it be intra-city. But in addition, if you will, Your Honor, the certificate itself does issue for 2 separate towns. So the argument could be that they are contiguous intra-city routes. So you have to have the approval of each of the particular towns of Acton and Maynard. And as you see in the certificate, Your Honor, they're very different approvals on each town. In one town, it's a very specific route. It says you have to go on particular streets. And in the other town, they decided to say you can use any of our streets to get from here to there. So they are 2 separate routes, if you will, Your Honor, and you could argue that those are separate and contiguous intra-city routes.
All right. If A&A, as I understand from Mr. Hampkin, that they started running that in April or June, and
Right.
they didn't actually get the Section 7 certificate until the end of August. So if, in April or June, they had purchased buses, would you say, for this run, and they get the certificate in August, you would still say, No tax, you don't?
No, you have to have the certificate in hand. And the fact that they were, the DTE did in fact testify, their representative testified at the hearing that the Section 7 certificates only operate prospectively.
Well, I gather that was not the case here. Or so
Well,
I
it was
infer.
obviously inappropriate that they were carrying on this service without the appropriate license in hand at the time. So the fact of the matter being that they did this, it was likely inappropriate. Without the certificate in hand at the time they were doing it, then they're not entitled to the exemption.
Okay. How do you distinguish the letter rulings?
Well, the letter rulings, Your Honor, again, the common construction is that with letter rulings, you have to have, one taxpayer cannot rely. Right.
we
But in
understand
addition, the facts have to be the same. There's a, if you will, a spectrum of informal policymaking procedures, as was noted in RCN BCOCOM and in Baybank. And the board is only, the commissioner is only bound to one extent or another, depending on sort of the formalness, if you will, of the actual pronouncements. On the one hand, you have, for example, technical information releases, which are quite formal and are broadly applicable. With respect to the letter rulings, however, letter rulings are quite informal, and they do turn on the specific facts that the taxpayer is asking the commissioner to rule on. Here, we don't have the same facts.
In what, let me ask you this, you're never going to have identical facts.
Certainly, Your
So tell
Honor.
me what the material
The
fact-
material difference here,
Yeah.
Your Honor, is in fact that the taxpayers that requested those letter rulings were not subject to the jurisdiction of DTE. Because they weren't subject to the jurisdiction of DTE, they couldn't obtain the Section 7 certificates that the exemption requires, and therefore the commissioner at that time determined that because they were providing the requisite service, that they would be entitled to the exemption. But, Your Honor, there's also the rule of construction in RCN BCOCOM that the commissioner would not be bound by letter rulings that interpret a statute that's unambiguous. You can't give undue weight to a letter ruling that reads words out of a statute, as happened here, essentially. The commissioner at this point has determined that that 6AA requires the certificate to be in hand at the time of the purchase, and because that's an unambiguous requirement of the statute, you can't read it out of the statute, and therefore the commissioner is not required to perpetuate an error that was essentially made 20 years ago. So for that reason, both that, in fact, that the letter rulings aren't relevant to this particular circumstance because the facts are materially different.
And you're suggesting that the commissioner wouldn't issue a letter ruling to that effect today?
Correct, Your Honor.
Now, if the Maynard-Acton line are two contiguous intracity routes,
Yes, Your
why is the UPS in Shrewsbury to Worcester line not two contiguous intracity routes itself?
It might be if they had actually gone to the DTE and obtained the appropriate certificate and gotten a ruling that in
Section
fact-
6 certificate? Or Section 7 certificate?
Section 7 certificate. Correct, Your Honor. If I
Okay,
misspoke,
so
I'm
you're
sorry.
resting then purely on the Section 7 ground, not on the intra-city ground.
You're right, Your Honor. We believe that you don't even have to reach that particular issue with regard to what is intra-city. That the case begins and ends, as Justice Cowan says, with the lack of a certificate at the time of the purchases.
Right, but it sounds like you're saying more than that, not merely that we should not reach it, but that if we were to reach it, you're relinquishing the position you took in your brief, which is that this is an intercity line.
No, Your Honor. I wouldn't go that far, in fact. As we stated in our brief, the standard with respect to interpreting, to judging the Appellate Tax Board's interpretation is reasonableness. And here we had in the statute a requirement that there be intracity service as defined by DTE. And of course, as we've heard, DTE doesn't define it. So without a definition from DTE, the Appellate Tax Board is left to interpret the phrase. Now, obviously, there is a difference between intra and inter, and because there is a difference between intra and inter, the board applied a common sense dictionary definition. Intra means within the city, and because it means within the city, then because this particular bus route went outside of the city, then that provided intercity bus service. The standard is merely reasonableness.
What is the common sense definition of intracity that says that you can't have intracity and intercity at the same time?
At the same time. Well, because I guess, Your Honor, the statute did make this distinction. The common sense distinction is, one is within and one is without. And that's as far as the board went.
No, I understand, but if one were to look at the purpose of the city, and for lots of reasons, because you have, at least in Massachusetts and some of the areas, that you have towns that are big enough to need intra-city
Right.
routes, but not big enough to support those even, 6 a.m. to, 7 p.m.
Right.
It seems that there's nothing that points me to saying that you can't have contiguous intra-cities.
That couldn't be exclusive. That's certainly true, Your Honor, and it's certainly true that there may be lots of reasons why the legislature would have adopted it. In fact, they may have said that exclusive within one city is something to be encouraged because there may have been plenty of intercity bus routes. You may have wanted to encourage routes within a particular city. That may have been something that was missing. But
do you know why they selected intra as opposed to inter?
No, Your Honor.
Is there any legislative history?
Not that we're aware of, no, Your
Okay.
Honor. And again, the standard for judging that particular issue is, of course, reasonableness. And because the board's interpretation was not unreasonable, it should be upheld. But again, there's essentially no reason to reach it because it does begin and end with the lack of the certificate. Because the AA Transportation didn't have the certificate in 1999 through 2001. In fact, because they applied for the abatement 6 months before they even applied for the Section 7 certificate, because the Section 7 certificate...
And they got it.
And they got it, but for a different route, if you will, Your Honor. There are two different routes. I mean, it doesn't say... They argue that the certificate offers only an evidentiary function. But in this particular case, it offers very little relevant evidence because it says nothing about their activities during the relevant time period, and it is for a different route. And so essentially, Your Honors, because they lacked the requisite certificate, they're not entitled to the exemption.
Ms. Mender, do you happen to know, either because there have been challenges or whatever, how many, whether there are a number of contiguous intercity bus services being provided?
I'm not aware of the status of any other licenses or how many there might be.
Now, is your reason for saying that the Section 7 certificate is required not merely the language of the statute, but also the process of obtaining an exemption statement, that you need to waive that Section 7 certificate in order to get the exemption statement?
Right. Again, Your Honor, that there is essentially in the plain language of the statute a process that's established. First, you have to come in and you have to show that you have to the commissioner that you have two things in hand, that A, you're actually providing the exempt service that you're trying to encourage, and B, that you have the certificate. And once you prove those things to the commissioner, then you issue the certificate, and then you take that certificate and you show it to the RMV when you're registering a new bus. So therefore, the plain language, again, establishes this process, which indicates that it can only act prospectively.
Could I ask you this? Let's now they have one, okay? Let's just switch these facts a little bit. Let's say for the Acton-Maynard line, they have a Section 7 certificate. They do or don't buy buses related to that. But then this UPS contract comes along, and they're doing what they're doing, and they're operating, and members of the public are getting on. They've got their certificate. Could they get the tax exemption because now they've got a certificate without anything more?
Right. The statute is not entirely clear on that issue, Your Honor, because it does say that any common carrier that holds at least one certificate, and but there are two things in balance. You have to provide that the required service. So you have to prove that the required service is what it is.
But you've got they waived the certificate in front of somebody. I guess the seller of the bus, right?
Right.
I mean, who do they have to prove that they're doing the required service to?
Well, I think that the issue would be for their own security if it would survive audit.
If it was what?
If it would survive an audit further on. I mean, you could certainly waive the certificate in front of a sellor.
But they don't. Okay, but there's nothing they have to do in advance in order to get that tax exemption once they have the certificate in hand for some route?
It would certainly be best for them to obtain a separate certificate for the separate route, because of course Section 7 certificates are for specific routes. So it would certainly behoove them to go out and get a separate Section 7 certificate for the specific route that they wish to run. And then it would also, to survive an audit, to show that in fact this particular, if the department would ever come back in and say, show us proof that this other route that you bought vehicles for comes within the meaning of the statute. But for practical purposes, could they just waive the certificate in front of someone and buy more buses? Yes, you could.
One other factual question. If you have in the Worcester-Shrewsbury situation, would the bus company need to go to each of those municipalities and get the route approved and then go to the
DTE?
department, or does the department do the routes?
Right. No, the towns say where they'll permit the routes first. You come to the DTE with that approval from the towns.
So that's, in the case of Maynard and Acton, that's what happened.
And that's exactly what happened. As you see the approvals from the two different towns, they list the routes that they approve, and those are the routes that go into the certificate.
And there was nothing from Shrewsbury and Worcester related to that UPS?
Not in this record.
Thank you, Ms.
Thank you,
Miller.
Your Honors.
SJC-10257, Commonwealth versus Lyles.
Thank you.